Hi, everyone. Welcome to Crime in Court. This is the Commonwealth versus Karen Reed Trial 2.0, and we are 21 days as of now away from the second trial for Karen Reed, and motions in limine have dropped. There have been many filings. Today's episode is titled Episode 122 Motions in Limine Trial Exclusions. So, because there have been so many filings that have dropped, I would be here for hours reading for you. So, I'm going to break them down into smaller segments and we'll kind of go from there. So, this episode, we're talking about things that either side wants to exclude from the trial. So up first, let's read the common. Oh, let me shrink myself first. Please hit that like button as we get started. And this is the Commonwealth's motion to in limine to. So a motion in limine is basically a lawyer can file a motion in limine to either exclude or include evidence at trial. So many of these are to exclude. So the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations. Who do you think that's about? Sustained findings unrelated to the case or unfounded allegations of misconduct. Yeah, so anything about Michael Proctor being under investigation, you can't bring that in. That's basically what the Commonwealth wants. No discussions about the disciplinary actions received by Kevin Albert because of this trial, Michael Proctor because of this trial, Yuri Buchanan because of this trial, and Brian Tully because of this trial. I might be forgetting some, but as you can see, there have been many law enforcement officers who have received disciplinary action or are in the middle of pending disciplinary action because of this case. It is due to this case, but they want to claim that it's all unrelated and you can't talk about it. And it's unfounded at this point. It's an allegation. It hasn't been confirmed, even though Michael Proctor has been on suspension nearly a year now. What, like 9 months or so? He went on leave uh, very shortly after the first trial. So um, unpaid leave. And he's had multiple hearings through two or three. I want to say he has his third one scheduled. And each of his hearings have gone for like 8 hours per day, and they just keep getting continued to another date. So I think the Massachusetts State Police are on purpose not letting Michael Proctor go so that they can keep him on as employed so that they can't talk about these unsubstantiated allegations. Come on, give me a break. But anyways, that's my opinion on that. All right, so the Commonwealth moves in limine to prohibit disclosure of or reference to any internal affairs investigations pending against any law enforcement witness. The Commonwealth further moves in limine to prohibit disclosure or reference to any internal affairs investigations with sustained findings as they bear no relevance, nor do the findings relate to any basis or to any bias exhibited by those against whom findings have been made. Um, but I would say that they're relevant. He says they bear no relevance, but this is related to the case, no? So how is it not relevant? Internal affairs investigations are confidential, and disclosure of any investigations that have not resulted in a sustained finding of misconduct would serve no purpose other than to risk materially prejudicing the proceedings or confusing the jury. Moreover, the Commonwealth moves to prohibit reference to any civil lawsuits filed against Canton Police Sergeant Lank relating to an incident that occurred nearly 20 years ago. Do you remember this? So there was an incident that occurred 20 years ago where Sergeant Lank was out drinking with his buddy Chris Albert, and Chris Albert got into an altercation with some other gentlemen, the Lapalato brothers, if you recall. We talked about them in previous episodes, and we went through the filings of what happened there. And Michael Link, he was out drinking, he was not on duty. He decided to um, take on police duties as someone who was drunk with these individuals and got violent, was inappropriately violent with these individuals, and there was a lawsuit, and they won. And the guys tried to go to the Canton, or I don't know what police department, but they tried to go to the police department and make a report after the things had happened. And then they're like, you know what? Just come back. The guy you need to talk to isn't here. Just come back later. And then, but before they even got to go back the next week or whatever it was, whatever day they told him to come back, they filed charges on the brothers, making it like the brothers' fault, even though Sergeant Length was the one that was the violent one. So there's that. So this is what the Lapalato brothers, I bring this up because the Lapalato brothers were on the witness list from trial one. I don't know if they're still going to be on the witness list this time around. We haven't seen the final witness lists yet. So that's up in the air if the Lapalato brothers will be called, but they are trying to get ahead of it. The CW is saying we don't want any information about these lawsuits. So relating to this incident that happened 20 years ago. In the federal lawsuit previously relied upon by the defendant, there were no adverse credibility determinations against Sergeant Lank or any findings of liability. The case was dismissed by agreement of the parties. They probably came to Sergeant Lank probably um, settled with the Lapalato Bros. I couldn't think of the word. All right, so until a finding of liability has been made, a pending civil lawsuit constitutes an unsubstantiated allegation of police misconduct that does not tend to negate the guilt of the defendant. Findings of civil liability made against prosecution team members in the performance of their official duties are subject to automatic disclosure and fall within the duty of inquiry. Pursuant to Graham versus District Attorney for Hamden District, if a police officer's credibility is a critical issue at trial, the judge has the discretion in the interest of justice to admit evidence of specific instances of the officer's false statements in prior unrelated matters. A judge, in deciding whether to allow a police officer witness in the interest of justice to be impeached with prior misconduct, may consider the age of the prior misconduct, the strength of the evidence of the misconduct, and the simplicity of establishing it, and whether the prior misconduct is probative of how the officer conducts police investigations. I think with that definition, she's not going to let it in right there. She's gonna be like, "That's my out. I don't need to let it in." I don't even know if they're trying to, but this is him trying to get ahead of it. In instances where there have been no sustained findings of misconduct, the jury should not be permitted to consider any allegations of misconduct, whereas disciplinary action is but one possible outcome, exoneration and protection of the officer and the department from unwarranted criticism is another. In instances where sustained findings have been issued which do not reflect untruthfulness on behalf of the officer nor exhibit any bias against the defendant by the officer against whom sustained findings have been made, the conduct is equally inadmissible and lacks evidence or relevance. Further, the Commonwealth requests advance notice and production of any reciprocal discovery related to any specific instances of prior misconduct or false statements that the defendant seeks to introduce to impeach or use to impeach any law enforcement witness. So remember, they have to turn in their impeachment materials, but they've asked her to reconsider that again, I think. And also, What was I going to say? Something came to mind as I was reading, and I didn't want to stop reading. I don't remember. Um, I don't know. Okay, so that's the end of that. So he's basically wanting to, like I said, get ahead of Sergeant Lank's stuff. He also, I think, wants no all those other officers that I talked about, Proctor, Yuri, Brian Tully, Kevin Albert, all those officers that I just talked about, they don't want their misconduct and their bad deeds coming in. So they're just trying to get ahead of that, the Commonwealth. And because it's Bev, she will probably be like, yeah, allowed, Hank. You're so good. And I just give you everything you want and turn the defense down at every corner. All right. Here is and the next motion in limine, which is also from the Commonwealth to preclude the defendant from raising a third party culprit defense. We knew this was coming because they did it in the first one. Basically, Hank has rehashed every filing from the first trial. So he's not really doing anything differently other than trying to exclude some of Karen Reed's witnesses and things like that. But for the most part, his tactic, his strategy, it's all pretty similar. So now comes the Commonwealth and respectfully requests the court preclude the defendant from raising a third-party culprit defense. The defense position has chronically been fluid and unsubstantiated. Okay, buddy. The defense claim has been nebulous from its origin. He used the word nebulous. He's such a dork. Karen, just to be clear, you didn't do it. We know who did it. So that was a reporter asked her, Karen, to be clear, you didn't do it. And then she says, we know who did it, Steve. We know. And we know who spearheaded this cover up. You all know. She she's right. Nothing about that is incorrect. Um After the first trial, the defense position began transformation. We're going to retool everything, and maybe some things will stay, some more, but we're going to shuffle a lot of things around. What? So? Wouldn't. Mm, So, so Hank is telling me that he hasn't tried to do some re-strategizing of the defense or of the prosecution? The defense has the option, the ability, the every right to to look at everything all over again and reanalyze and come at it with a different approach. That's not a bad thing, and that's not nebulous. Most recently, in its Fox 25 sit down, the defense responded to the question, in your opinion, there have been a few names that have surfaced in this third party culpability theory. Who do you think, if John was beaten up and attacked in that house, who did it? Defense counsel uttered, we don't know. The defendant quickly echoed, we don't know. Counsel further said, and it's not for us to know. Somebody other than Karen. Somebody other than Karen is responsible for that, for the homicide of John. But who is it? Who was it specifically? Others know, and they're not talking. Where's the inconsistencies? There's nothing that they've said that isn't consistent with a prior statement. Am I in crazy town? I really do feel like it with this trial. All right, the evolving responses have vacillated from an unidentified certain villain to not knowing who is responsible and have been the hallmark of the defense's third-party culprit claims since its inception. Well, no, because they've always said that they don't know exactly who it is, but it likely could have been Colin, Brian, and Brian. And when she was arrested or indicted the second time, whatever it was, when she was indicted and Yuri Buchanan was checking her in at the station, and she's like, "You're kidding me, right? John's face is I can't remember the word she used. Um, I can't remember what word she used, but basically, like his face is bashed in, and my tail light has a crack." She's like, "We're all in on the same joke, right?" I mean, it's she even said in that um like in that portion of that video, she said something about Brian, and I think she might have even mentioned Colin and or Brian and his nephew did it or something like that. So she's always known or suspected that it was them. She's not, just because they say that they don't know doesn't mean that she's backtracking. They've always been clear that they don't know who specifically it was that landed the blows that actually took John's life. Prior to the first trial, the court made rulings relative to the defense's third party culprit claims. The court ordered, based on the offer of proof on Friday, I am well within my rights pursuant to the case law to exclude the third party culprit defense. I'm not going to do that now. I am going to give you a chance. What is he talking about? Oh, that's her quote. So the court said this in a prior ruling for the first trial about the third party culprit defense. She says, I'm not going to do that now. I am going to give you a chance to develop it through relevant, competent, admissible evidence, but you cannot open on it. So that is my ruling on it. So they couldn't bring it up in their opening, which they did not, and they tried to bring it in through third party evidence, which I believe they proved that someone in that house did something and it wasn't Karen. So, despite the court's clear ruling, the defense launched into its third party claims from the beginning of its opening statement. Karen Reed was framed. Her car never struck John O'Keefe. She did not cause his death, and that means that somebody else did. So what is what are they supposed to say, Hanky? If it's not her, then somebody else did it. And if it's not her, then somebody planted her taillight there. He's such a moron. God, I can't take this man anymore or this injustice. I'm just so sick of it. All right, followed by because the Alberts were involved and because they had close connections to the investigators in this case. Karen Reed was framed for a homicide that she did not commit. The evidence identifying or establishing a third party culprit was never forthcoming throughout the trial and to this day continues to be non existent, if you say so. The Massachusetts Guide to Evidence provides that evidence that a third party committed the crimes charged against the defendant or had the motive, intent, and opportunity to commit the crimes is admissible, provided that the evidence has substantial probative value. In making this determination, the court must make a preliminary finding that the evidence is relevant, is not too remote or speculative, and will not tend to prejudice or confuse the jury. If the evidence is otherwise inadmissible, the court must also find that there are substantial connecting links between the crime charged and a third party or between the crime charged and another crime that could not have been committed by the defendant. After 3 years, the defendant has yet to provide any evidence as to whom they suggest is the third party culprit responsible for the victim's homicide and or any evidence of alternative circumstances that would have caused the victim's death. They've given alternative circumstances. They've told the world what they think happened. Just because the Commonwealth doesn't like that that implicates the people in that house and in doing so it also implicates a poor investigation and some familial ties between investigators and witnesses slash suspects. I mean, come on now. But they have given alternatives. They do think that they know what happened. They just can't prove it beyond a reasonable doubt. The absence of an evidentiary basis to support a third party culprit defense was clear before the start of the first trial. To accept the defendant's third party culprit defense, the court would have to find the defendant demonstrated that the acts of the other person are so closely connected in point of time and method of operation as to cast doubt upon the identification of the defendant as the person who committed the crime. Well, gee, I don't know. All of the Alberts and everybody inside that house, like I have said from the beginning, is complicit in, if not the murder, the cover up of the murder of John O'Keefe. So every single person in that house should be arrested. Every single one. Now, who actually laid their hands on John? That's another story, but you can kind of guess based on actions before that night, things that happened in the bar. The grab assin with Brian Higgins and Brian Albert, and they're Brian Higgins trying to call John to come outside. So there was a lot of reason. There's motive there. There's all sorts of things that are necessary. The motive, the intent, the opportunity, the time, it said within the time frame. So they were right there, everybody was at the bar together, relatively close in time. They all left the bar and went to the Alberts house. So it's not unheard of that somebody from the Alberts might have been a suspect rather than Karen if they were all in the same proximity near the same time. So everyone in that house, if it wasn't Karen, then everyone in that house is a suspect slash complicit. All right. Where did I leave off? The acts of the other person so closely connected. I read that. The evidence must have a rational tendency to prove the issue raised and cannot be too remote or speculative. Therefore, the defendant would have to prove evidence of substantial probative value that another individual had the motive, intent, and opportunity. Motive? Oh, I don't know. Brian Higgins might have been jealous of John O'Keefe. Colin Colin and John were neighbors and they didn't get along, and he was always in their yard, and the Alberts were total jerks basically and were always like instigating things, including especially Colin with John. So there's some motive, there's some intent, there's two people right there. I don't know about Brian, but Brian seems like a hothead and he would just go to bat for whoever in in his little circle might be mad at somebody. So if somebody else is mad, then Brian Albert might get in. If Brian Higgins is mad at John, then or Colin, his nephew, is mad at John, then Brian Albert might get in on that motive of wanting to exact revenge or whatever on John. So that was motive, intent. What we saw in the bar, I already said the grab assing and the, Higgins calling John over from like right before they left, he was calling him out to come, and you see Chris Albert putting his hand down and saying, "Don't do that, don't do that," so he was kind of like stopping him. So there's possible intent. Why did they want them there? Why was Jennifer McCabe saying, "Hey, Karen, come with me," and trying to separate Karen and John at the end of the night? What's the intent there? Opportunity? They were all there, all of them. Remember, they were all at the bar, Waterfall, and then they all left in separate cars, but they all went to the same place. So just to say that Karen is the only one that is a suspect is ridiculous to me because every single person in that house should have been a suspect that night. So, motive, intent, and opportunity to commit a homicide, but vehicular manslaughter and leaving the scene. Well, that's your theory, but that's not at all what the medical examiner says. So there's that. Introduction of third party culprit evidence subject to ordinary considerations of relevance. To raise a third party culprit defense to one charge that is closely intertwined with the other charges would pose a real threat of prejudice by confusing jurors and diverting their attention to wholly collateral matters involving persons not on trial. Excluding third party culprit evidence where testimony was consistent between proffered culprit and other witnesses including police and EMTs who arrived on scene. The defendant's arguments that culprit would have fabricated story to implicate defendant strained credulity and was entirely speculative. No, it's not. They tried to impeach Catherine McLaughlin, Katie McLaughlin, but they couldn't because Judge Bev wouldn't allow it in. When Katie McLaughlin was like, "Oh, I went to high school with somebody named Caitlin Albert." No, girl. You went to college with her too, and you were friends like all throughout high school and college. And there's pictures of you hanging out and going on vacations and things like that. So, but yet Bev would not let it in. I'm already annoyed, and this trial hasn't even started. The defendant's right to present a third party culprit defense is not absolute, and the admission of feeble third party culprit evidence poses a risk of unfair prejudice to the Commonwealth. Whatever, buddy. There is so much evidence of third party culpability that it's unbelievable we're still here. This case should have been dropped forever ago. He says that the admission of the third party culprit evidence poses a risk of unfair prejudice against the Commonwealth because it inevitably diverts jurors' attention away from the defendant on trial and onto the third party and essentially requires the Commonwealth to prove beyond a reasonable doubt that the third party. No, 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 no. What is he even quoting here? Commonwealth versus Silva Santiago. So they're saying that the Commonwealth then has to prove beyond a reasonable doubt that the third party suspects aren't guilty. Well, that's too darn bad. If your witnesses suck, if your witnesses are terrible, that's on you. That shouldn't don't handicap the defense because your witnesses can't stand up to cross examination. All right. The defendant's ability to mount a third-party culprit defense is not without limits. Additionally, hearsay offered for the truth of the matter asserted that a third party is the true culprit and not within a hearsay exception may be admitted only if the judge's discretion, the evidence is relevant, will not tend to prejudice or confuse the jury, and there are other substantial connecting links to the crime. Trial judge correctly excluded third-party culprit evidence involving four identified individuals, including evidence that victim was nervous around individual who had criminal record and evidence that one was initially a suspect in police investigation as evidence was speculative and remote. The case they're citing there that they think is relevant. The defendant's proffer that victim was shot by an unnamed rival drug dealer was nothing more than rank speculation. Evidence individual was banging on victim's apartment door the day of her homicide at most suggested opportunity to commit the crime an attempt to attribute that to motive or intent to take the life of her would be impermissibly speculative. But I just gave you all three. So I gave you all three. It wasn't just speculative. They have means, motive, opportunity, whatever. They could have done it. All right, testimony of witnesses that in days prior to the homicide, victim had expressed fears about being harmed as a result of problems with an unknown woman and stuff in the past was of minimal probative value and not admissible. Why? Like these things should come in, I think. Evidence that third party appeared at the crime scene around time of homicide did not constitute substantial link between third party and the homicide. This court has the discretion, and she loves to remind the defense that it's in my discretion to do this. So this court has the discretion to rule in advance of trial whether the defendant has made an adequate showing that potential culprits were connected to the crime. The defendant must provide advance warning to the court before offering third-party evidence or argument at trial. Judge's determination of relevancy will not be set aside absent an abuse of discretion. The defendant has yet to make a proffer of substantial probative value Yeah, right. That any other individual is culpable for her crimes. The only crime that she's committed was driving away from her boyfriend when he didn't respond back to her. That's her crime. And going back to his place and staying there so that his niece, adopted daughter, wouldn't be alone. That's her crime. And paying for people at the bar and, being a generous human. That's her crime. So ridiculous. All right. The arguments previously set forth by the defendant in pretrial motions contain only vague inferences, rank speculation, and scant details of who, if anyone, had the motive, intent, and opportunity to take the victim's life. A third party culprit is simply a defense tactic to unjustly prejudice the Commonwealth and confuse the jury. No, it is not, buddy. It's not. She has a right to defend herself. And if she didn't do it, somebody else did. And if she didn't do it, the jury's going to want to know who did. And there's plenty of evidence to indicate that people inside that house did it. The trial tactic is, like any other, limited by the fundamental principle that evidence must be relevant if the defense offers its own theory of the case beyond merely putting the government to its proof. Its evidence must have a rational tendency to prove the issue the defense raises, and the evidence cannot be too remote or speculative. For the foregoing reasons, the defendant should be precluded from alleging that any other individual is culpable for the victim's homicide, as there is no relevant or substantially probative evidence to justify the admission of such a speculative claim. Man, is he full of it. Furthermore, despite this court's previous order denying the defendant's request to raise a third party culprit defense during the defendant's opening statement at the first trial, Attorney Yannetti was permitted to declare 3 separate times that Karen Reed was framed. Should the court preclude the defendant from raising a third party culprit defense counsel should be ordered to conform their arguments to the orders of the court. He is such a weenie. He's such a nerd. I cannot stand him. Hank Brennan can suck a big toe. All right, let's get to the defense's motions to exclude certain things. This is not all of their exclusions. This is not everything, but this is a good portion of what came in today. I'm going to have several videos to go through all of these different motions. So just be aware that there might be more motions to exclude things. This isn't all of them. This, however, is the defendant's motion to impound the defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and/or intimidation of witnesses. I'm sure this has to do with the whole trying to tie Karen Reed and Turtle Boy as some kind of co-conspirators to intimidate witnesses. So now comes the defendant, Karen Reed, and respectfully moves the Honorable Court for an order impounding the defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and/or intimidation of witnesses. Good cause exists for the impoundment of the motion because it makes reference to grand jury proceedings, so anything grand jury needs to be sealed. So I'm sure she allowed that. All right, up next, or will allow it. All right, up next is the defendant's motion in limine to prohibit testimony regarding funds paid to experts for purposes of voir dire. What do you think that's about? Yes, the ARCA experts. So if you recall, so Adam Lally wanted a Daubert hearing on the testimony from the ARCA experts, which Karen had to do. She had to fly them in. They had to sit for a Daubert hearing. She had to pay for travel, hotel, all the prep work that went into them, like rereading their notes and things like that. So all of that time was paid by Karen. After the trial, she didn't know that she was going to be having to pay that time. It wasn't informed of her, it wasn't told to her, but that is what happened. So after trial, she got a bill for 16 something dollars, and they asked the AG's office, "Can we pay it?" And they're like, "Yeah, you can pay that." So everything before that had been paid by the feds. So this was a surprise to the defense. It came after trial. The bill came after trial. It was paid after trial. So everything that they have said up until this point, that they didn't pay for the testimony of the ARCA experts. But of course, Brennan is going to try to use that $16,000 against the defense because she paid for their expenses, which is required and somebody had to. I mean, these things aren't free. So I don't even know why you should be able to bring it up, what experts cost and things like that. So, defendant's motion in limine to prohibit testimony regarding funds paid to experts for purposes of voir dire. Now comes the defendant, Karen Reed, and respectfully moves this honorable court in limine to exclude testimony regarding expenses incurred by Ms. Reed for expert voir dire. Given that these expert expenses were incurred based solely on the request of the Commonwealth. So the only reason we had to bring you in for a voir dire was because Adam Lally requested it. Their inclusion in testimony would not be probative of any fact of consequence and would only be unduly prejudicial towards the defendant. So if you start asking about the funds that we paid for them to come out and do the voir dire, it's only going to prejudice my defendant, or the defendant, my client. Factual background. In advance of both the first and second trial in this matter, the Commonwealth requested and the court ordered in-person voir dire for defense expert witnesses, including Dr. Daniel Wolf, Dr. Andrew Rentschler, and Dr. Marie Russell. As a result, Ms. Reed had to expend significant resources to pay for out-of-state experts to travel to Norfolk Superior Court for voir dire hearings, which spanned multiple days, and I think was done by design to try to diminish Karen Reed's defense funds. To the extent that the Commonwealth seeks to cross-examine these experts regarding any fees that they have been paid to testify in connection with this case, the Commonwealth should be precluded from eliciting testimony regarding any fees expended to have the experts testify at voir dire hearings which were conducted at the Commonwealth's request. The argument is expenses incurred by Ms. Reed as a result of expert voir dire are irrelevant. The fees and expenses related to expert voir dire are entirely irrelevant to expert credibility and do not make any fact of consequence more or less probable. Discussion of the fact that an expert witness is compensated for their time is acceptable so that juries may assess expert credibility and bias. Holding that while discussion of an expert, Commonwealth versus Bishop, holding that while discussion of an expert's standard fees is acceptable, suggestion that the expert is a hired gun is impermissible. So, Hanky, you can't do that. However, testimony about fees and expenses incurred as a result of voir dire have no bearing on an expert's credibility at trial. This is particularly the case here, where in-person voir dire was conducted at the request of the Commonwealth and where a significant portion of voir dire expenses came from travel and lodging. Discussion of fees and expenses incurred by the defense for expert voir dire would not provide the jury with any additional clarity about expert motivations or biases. So, just the fact that you paid for their lodging and expenses doesn't mean that you're paying for their opinion. The in-person voir dire of experts was conducted at the Commonwealth's request, and that's important. That's an important factor. Like, you can't force us to come there, spend money on them, and then force us to disclose how much money we spent and make it seem like it was, a bad thing or a nefarious thing somehow. Moreover, the defense would have no way of clarifying this issue on redirect without eliciting the fact that there was a voir dire hearing, which is information the jury should not be privy to and would not understand. Voir dire fees and expenses are separate from potentially relevant fees and expenses accrued at trial and therefore should be excluded. So that's a pretty good argument that they're different than fees relevant to um, expert fees for trial. All right, so the discussion of expert voir dire expenses would be significantly more prejudicial than probative. Even if testimony regarding fees and travel expenses incurred for experts' testimony at a voir dire hearing is deemed relevant, it would be far more prejudicial than probative. Evidence deemed relevant may be excluded in a variety of circumstances, including where probative value is outweighed by risk of unfair prejudice, confusing the issues, or misleading the jury. Exclusion is appropriate where the prejudice created by the testimony is unfair and may cause the jury to base their decisions on something other than the established propositions in the case. So if you bring it in, it could be unfair and prejudice the jury. It can confuse them. They might not understand, especially with it being voir dire. So, it shouldn't come in. Further, on cross-examination, a party may ask a witness questions pertaining to potential bias. However, where the relevance of the proposed evidence is of no more than marginal value to the party conducting the cross-examination, the judge has discretion to exclude the evidence. Discussion of expenses and fees for expert witnesses incurred as a result of the lengthy voir dire hearings would be highly prejudicial while lacking probative value. Expert fees and costs related to voir dire required by the court has no bearing on expert bias at trial. However, because these expenses were high, particularly whereas here at least one expert had to testify at two separate voir dire hearings, the jury may come away with negative assumptions and feelings towards Miss Reed. They may make assumptions about her financial situation or believe that the costs and expenses are related specifically to expert trial testimony. The jury would feel that experts are hired guns based on these inflated numbers or come to judge Ms. Reed based on the assumptions about her financial situation. Such emotional considerations may impermissibly cloud the judgment of the jury and could lead to decisions based on these emotions rather than the established propositions of the case. So, again, it is going to make they're not going to understand it. It's going to confuse the jury. It's going to make them look like hired guns. It's not exactly that, I mean, that is not true. And they're completely two separate issues. This prejudice would not be remedied by an explanation of the expert voir dire process. In fact, such explanation would only serve to further prejudice Ms. Reed and to confuse the jury. So there's no real good remedy other than to allow them to, or not allow them to discuss the fees for how much it costs for them to come in for the voir dire. So in fact, such explanation would only further prejudice Ms. Reed. When expert voir dire is conducted out of the presence of the jury, the separation may be viewed as a tool to prevent bias towards or against the expert. Although it is for the court to determine, so the jury might see it as some kind of bias towards the expert if there is a voir dire, if they know that they had to be questioned without the presence of the jury nearby, or in the presence of the jury in the room. Although it is for the court to determine whether a witness is qualified to testify as an expert, there is no requirement that the court specifically make that finding in open court upon proffer of the offering party. Such an offer and finding by the court might influence the jury in its evaluation of the expert, and the better procedure is to avoid an acknowledgement of the witness's expertise by the court. Commonwealth versus Richardson, quoting United States versus Bartley. While Richardson is specifically focused on whether a judge must qualify an expert as an expert in front of a jury, it illuminates important considerations about the expert qualification process that are useful in this context. Ultimately, disclosure of fees and expenses incurred for expert voir dire would create an inaccurate and improper image of Ms. Reed's financial situation, causing unfair prejudice and a serious risk that the jury make credibility determinations based on the fact that voir dire was conducted at all. So just the fact that they know that an expert went through the voir dire process could prejudice them in some way against that expert. Knowing this money too is and shedding some light on, improperly, you know, m- um, people could make inferences about her financial situation. All right, so the discussion at trial of expert voir dire expenses would undermine the voir dire process and principles of fairness. The purpose of experts sharing their standard fees on the stand is to allow the jury to hear and consider potential bias. Voir dire may be used to determine an expert's qualifications and the admissibility of the facts underlying their testimony. Allowing testimony at trial regarding expenses incurred as a result of the voir dire hearings would undermine both the purpose of expert fee disclosure and the integrity of the expert voir dire process. If voir dire expenses are shared at trial, it could incentivize parties to insist on in person expert voir dire to drive up litigation costs for the other side and then present that inflated number to the jury to create a misleading and prejudicial image of the other party. This incentive would pervert the voir dire process, turning it into a potential trial weapon as opposed to a tool used to assess expert qualifications. Conclusion: allowing testimony about the costs incurred by Ms. Reed during the expert voir dire process would be irrelevant, far more prejudicial than probative, and would ultimately undermine the integrity of the voir dire process. Therefore, Ms. Reed respectfully requests that discussion of expenses incurred as a result of in-person expert voir dire be excluded from all testimony at trial. What do you think? Is Judge Bev going to allow that? I hope, but I have no confidence that she's going to ever rule in favor of the defense again. She has turned the corner. She is officially corrupt. If you didn't think so, you can now. So I don't think there's any coming back. She's doubled down on her part in it because she's complicit now in framing an innocent woman with the role that she's had in the jury process, in her rulings, in all of it. So that's what I think. All right, this last final motion to exclude, like I said, it might not be the last motion to exclude something, but for today, there were so many filings, and I have so many other videos that I got to get done for you to catch you up on them. But for today, this was the big portion of what we actually had, which were like exclusions from trial testimony or evidence or whatnot. So I wanted to give that to you first because those are kind of a big deal. They kind of give you an idea of what strategies the both sides are coming up with. So here is the final what am I trying to say? The final motion in limine that I'm going to read to you is to exclude a false and irrelevant statements of Michael Proctor. So this is from the defense. Now comes Karen Reed and respectfully moves this honorable court in limine to exclude any references to trial to false personal accusations made by State Trooper Michael Proctor against Attorney David R. Yannetti, including but not limited to Trooper Proctor's false allegation that David or Mr. Yannetti purportedly parked in the parking lot of a school in order to harass Trooper Proctor's sister, Courtney Proctor. During the first trial of this matter, Trooper Proctor falsely claimed that when Mr. Yannetti had gone to the parking lot of the school where Courtney Proctor was allegedly employed, he, one, refused to leave the school parking lot when confronted by a teacher, and two, upon being confronted by a teacher, he asked about Courtney Proctor's whereabouts and asked whether she worked at the school. So that was from Proctor's testimony. That's what he claimed. Both assertions are false, as demonstrated by the police report of Canton Police Officer Eric Kos- Koskov- Koskovich, we'll go with, dated June 12th, 2024, attached here to Exhibit A. See also the affidavit of David Yannetti in support of this motion. This says sorry, the first page of the report has been redacted to excise personal information of the involved parties. All right. Factual background. Ms. Reed is accused of the following crimes arising out of the death of Officer John O'Keefe: homicide in the second degree in violation of Massachusetts statutes, manslaughter while under the influence of alcohol, and leaving the scene of personal injury and death. On June 10th, 2024, Trooper Proctor testified as a witness for the Commonwealth in Ms. Reed's first trial. On direct examination, he testified that while the investigation of Ms. Reed was ongoing, he sent text messages to other members of the Massachusetts State Police about Attorney Yannetti saying, "I hate this man. I truly hate this man." And that was on June 10th that he testified to that. On redirect, which occurred on June 12th, Trooper Proctor was asked to clarify why he disliked Mr. Yannetti. During his response, Trooper Proctor falsely claimed that Mr. Yannetti had gone to the parking lot of a school where Trooper Proctor's sister worked the day before in order to harass her. Trooper Proctor falsely claimed, apparently referencing rank and false hearsay, as Trooper Proctor did not claim to have been present when Mr. Yannetti was there, and Mr. Yannetti had been asked to leave the parking lot but refused. Trooper Proctor had falsely alleged that Mr. Yannetti asked someone at the school if Michael Proctor's sister was working there that day. He testified that Courtney thought that she was being served, although there was no evidence that Courtney Proctor ever saw Mr. Yannetti that day. At the, did I miss? Oh, here, the trial had an off day on June 11th, is what they're saying. So he testified on the 10th, and then the 11th was an off day, and then the 12th he testified again. So at this point in the testimony, defense counsel objected, and the court requested that counsel approach at sidebar. After consulting with counsel, the court correctly concluded that Trooper Proctor's testimony regarding Mr. Yannetti should be stricken from the record and instructed the juries to disregard the testimony. After the trial ended in a mistrial, defense counsel received a copy of a Canton Police Department incident report that was filed in relation to Mr. Yannetti's presence in the school parking lot on June 11th, 2024. We have a footnote. Notably, the report was not provided to the defense during trial when the defense could have used this information to further impeach Trooper Proctor's credibility, but wasn't given the opportunity because they didn't have the information. Seems like a problem with the Commonwealth that they somehow forget or somehow have problems turning over discovery. Isn't that interesting? Continuing on, the incident report directly contradicts every false allegation from Trooper Proctor's testimony on June 12th, 2024, and shows that Trooper Proctor made completely false statements under oath. This incident report states that the principal of JFK Elementary School contacted patrolman Eric Koskovich, the school resource officer, to make him aware that Mr. Yannetti and Brian Lucky Lawfren, who is the plow driver who saw the Ford Edge and did not see a body at 2:30, but then at 3 saw a Ford Edge in front of the Albert home. So this is saying that the school resource officer to make him aware that Yannetti and he was meeting with the school resource officer. The incident report states that the principal of JFK Elementary School contacted So the principal of the school contacted an officer. Oh, he was the school resource officer to make him aware that Mr. Yannetti and Brian Lofgren had been seen in the school parking lot that day. The principal informed Patrolman Koskovich that Mr. Yannetti and Mr. Lofgren were not approaching the school, students, or staff, and that that she only wanted to make Patrolman Koskovich aware in the event that things escalated or hit social media. What? Why? Paskovich responded to the school and spoke to the principal and others at the school. He detailed that it was reported that neither individual ever approached the school, students, or staff members. Patrolman Koskovich observed Mr. Yannetti, Mr. Lofgren, and two individuals pull into the parking lot, talk for 5 to 10 minutes, and leave the parking lot in their separate cars. Patrolman Koskovich wrote that none of the four ever pointed at or approached the school, staff, or students. Trooper Proctor's claims that Mr. Yannetti was asked to leave, refused to leave, and inquired about Courtney Proctor were all completely fabricated during his sworn testimony. So, yet another thing Trooper Proctor lied about. Trooper Proctor should be disallowed from making these types of inflammatory accusations against Mr. Yannetti at Ms. Reed's retrial. Any evidence related to Mr. Yannetti's presence in the school parking lot must be excluded, along with all false accusations that Mr. Yannetti harassed or intimidated Courtney Proctor or other members of the Proctor family. Trooper Proctor's various testimony and any statements regarding Mr. Yannetti's presence in the parking lot are completely irrelevant to the issues presented at trial, and there is no probative value to the fact that Mr. Yannetti appeared in a parking lot to permissibly and appropriately prepare a witness to testify. All he was doing was meeting with Brian Lofgren to prepare him to testify. Yet they made this big deal out of it and somehow made it into a thing with Courtney Proctor, which has nothing to do with anything. So, as set forth, the evidence must be excluded. Here is the argument. Evidence of David R. Yannetti's presence in the school parking lot lacks any probative value and is therefore inadmissible. The court must exclude any mention of Trooper Proctor's false allegations that Mr. Yannetti went to the parking lot of the school where his sister works in order to harass her. Motions in limine concerning the introduction or exclusion of purportedly relevant evidence are properly made and considered before and during trial, in advance of the evidence being offered. The purpose of a motion in limine is to prevent irrelevant, inadmissible, or prejudicial matters from being admitted in evidence, and in granting such a motion, a judge has discretion similar to that which she has when she's deciding whether to admit or exclude evidence. Relevant evidence has any tendency to make a fact more or less probable. 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 Relevant evidence has any tendency to make a fact more or less probable. Importantly, the fact that the evidence makes more or less probable must be of consequence in determining the action. Whether Mr. Yannetti was in the parking lot of the school, I'm going to zoom in. Whether he was in the parking lot of the school where Courtney Proctor allegedly worked is of no consequence in determining whether Ms. Reed is guilty or not guilty of the charges against her. This evidence has no probative value as to the events the night of Mr. O'Keefe's death, and any fact that would be of consequence is determining Ms. Reed's guilt. Because the evidence is completely unrelated to any consequential facts in this case, the evidence must be excluded as irrelevant and inadmissible. The proffered false allegation is inflammatory and prejudicial and is therefore inadmissible. This court must exclude proffered false allegations because in addition to the complete lack of probative value to Mr. Yannetti's presence in a parking lot to prepare a witness, the false allegations are inflammatory, unfairly prejudicial, and would confuse the issues in this case. Through his testimony, Trooper Proctor essentially and clearly falsely accused Mr. Yannetti of purposefully harassing Courtney Proctor at her place of work. This accusation is inflammatory, which is likely the reason that Trooper Proctor unethically injected it into trial in the first place, and could lead the jury to harbor some animosity against Ms. Reed based on their emotions towards Mr. Yannetti and the defense team, rather than focusing on relevant and material evidence. Additionally, Trooper Proctor's accusations are baseless and false, making their admission even more unfairly prejudicial to Ms. Reed. Given Trooper Proctor's lack of first-hand knowledge regarding a false allegation that he purposely and recklessly tried to put in front of the jury, there are only three explanations for this testimony. One, someone lied to him about what occurred in the parking lot on June 11th, 2024, and he testified to it without doing any further investigation to find out if it was true. Two, Trooper Proctor somehow misunderstood what was being told to him and never sought to clarify that information before testifying to it under oath. Or three, Trooper Proctor blatantly lied. I think that's what it is. Trooper Proctor blatantly lied about what occurred in a desperate attempt to take attention away from his egregious misconduct in conducting and manipulating this investigation to get the result that he sought. Justice be damned. The defense has its suspicions about which explanation makes the most sense, but whatever the reason, his testimony was false, misleading, and speaks poorly of Trooper Proctor's ethics and investigatory skills. If allowed to testify at the retrial about his fictitious interpretation of what occurred in that parking lot on June 11th, there would arise significant danger that admission of that evidence would unfairly prejudice Ms. Reed. Admission of this evidence would also confuse the issues in this case. The question for the jurors in this case is whether Ms. Reed is guilty or not of the charges listed earlier in this motion. The presence of one of Ms. Reed's attorneys in a parking lot of a school in order to do his job as a lawyer, i.e., to prepare a witness to testify, is not at issue in this trial. Admission of the evidence would improperly distract the jury from deciding the questions of fact that are at issue in this case. And for all those reasons, this should be denied. We lost the last page there to that, but that was the end of it. So there you have it. Those are the most recent motions to exclude. For the motions in Limine, that was the big batch of motions that was put on the docket today. People have been furiously posting images and links and things. So thank you to all of those folks. And yeah, I will keep. Motions are still coming in, by the way. They're not even done. And it's the end of the day, and motions are still being updated in the docket because there's that many of them from their motions in limine that were due yesterday, Monday. So there you have it. There, we'll get through them as we can. So please hit that like button and don't forget to subscribe. And I will see you guys in the next one. Take care. Bye now.